we start? Good afternoon, everybody. Can you hear me okay? All right. So just to make sure I'm in the right place, this is a group of first-year law students at Case Western, and we're going to be talking about not guilty by reason of insanity. I'm in the right place? Good. All right. So here's who I am. My name is Stephen Noffsinger. I work in psychiatry, the Department of Psychiatry, and I run a forensic psychiatry fellowship program. So we train psychiatrists in the subspecialty of forensic psychiatry. So you might ask yourself, first of all, well, what is psychiatry? So it's a field of medicine. So psychiatrists are physicians, either MDs or DOs. And we're concerned with the evaluation and the diagnosis and the treatment, as well as research regarding mental disorders. And forensic psychiatry is a subspecialty within psychiatry. And we're concerned with evaluating psychiatric matters that arise in a legal context. And I'll give you some examples here shortly. This talk, besides summarizing not guilty by reason of insanity, is a preview and a plug for a course that I, along with a colleague of mine, Dr. Susan Hendricks-Friedman, teach to second and third year law students during the fall semester. So it's a course on law and psychiatry. So in this course we go through, spend about 2 weeks on the basics of psychiatry. We talk about competence to stand trial and other kinds of criminal competencies, the insanity defense, and we talk about a number of civil areas in which forensic psychiatry is involved, such as malpractice, disability, psychological damages, and other topics. And so the next few slides just summarize some of the things that we do and we talk about in the course, just so you know what forensic psychiatrists encompass in their practice. So let's talk about not guilty by reason of insanity. And I'm going to preview in the next two videos a case that we'll discuss about an hour into the talk. So this is a man named Philip, and he was charged with the murder of his mother, and he pled insanity. And so the next few slides we'll have Philip discussing his symptoms of his illness, and then just a brief discussion of the act itself. So after we have some more discussion about the insanity defense, then we'll come back. We'll have 6 or 8 slides about Philip, and we'll kind of analyze whether we believe he qualifies for not guilty by reason of insanity.
More or less constantly, because I didn't want to take it. I had a lot of paranoia, and I thought my family and my wife and my mother and my brother and other people were out to get me, and they were trying to, I guess it seemed to me, to stop me from accomplishing the mission that I was supposed to carry out by spiritual chemical castration, I guess you could say.
What kind of mission was that?
I wasn't really sure what the mission was, and that's why I would read the Bible really a lot for long periods of time, because I thought that the answer to it was contained in the Bible, and that if I could just discover what my purpose was that I was supposed to do, I could alleviate all the problems, and I would return to normal and basically save the world from the evil people.
All right, so we had spiritual chemical castration, which we'll hear more about coming up.
More or less constantly, because I didn't want to take it. I had a lot of paranoia. I reached into a drawer in the kitchen cabinet, and my hand just grabbed a pair of scissors. It grabbed onto a pair of scissors, and I pulled the scissors out and I stabbed her one time in the back, which hit her lung.
All right, so that's just a preview of a defendant talking, at least beginning to talk about the murder of his mother.
I reached.
All right, now also to just whet your appetite, I've got a few pre-test questions for you, or pre-lecture questions. And just think to yourself how you might answer these questions here. The first question is that defendants frequently plead not guilty by reason of insanity. True or false? Think about that. The insanity defense is usually successful. True or false? I can see some people did the readings. A defendant who's found not guilty by reason of insanity for aggravated murder can be released back into society. True or false? Insanity acquittees frequently reoffend. True or false? And finally, insanity acquittees may refuse psychotropic medications. So even if they're found to be not guilty by reason of insanity, can they choose to not take medications for their acknowledged illness, which has made them break the law? All right, well, to begin our discussion about insanity, we have to go back and talk about some basics of criminal law. And I realize I'm preaching to the choir here since this is a class of criminal law students here, but please forgive me if I go over information that you're already familiar with. So as you know, in order for a prosecutor to seek or to secure a conviction, you must prove both elements of a crime beyond a reasonable doubt, the actus reus, the forbidden act, and the guilty mind, the mens rea. The exception to that would be a strict liability offense where only an actus reus is required. And I like the way that U.S. Supreme Court Justice Robert Jackson coined this. Criminal liability is based upon the concurrence of two factors, an evil meaning mind and an evil acting hand, which I found some depictions for here. Now, in the law, there are these affirmative defenses in which a defendant affirms or admits that they committed the actus reus, but they assert that they're not liable criminally, and they're asking for acquittal due to special circumstances. So when a defendant raises one of these affirmative defenses, then the burden of proof shifts from the prosecution to the defendant to prove the existence of the affirmative defense. And we can break down these affirmative defenses into two major categories, a defense of justification or a defense of excuse. So a defense of justification in which a defendant asserts that yes, the actus reus was committed, but that the actus reus itself was permissible, that it wasn't wrong. So an example of that would be self-defense. That the harm caused by the act and the harm caused by deviating from the law, when you weigh it against the social benefit of the act, the social benefit of the act outweighs it. And so in a defense of justification, we're looking at the act itself, not the blameworthiness of the actor. And here are some of the affirmative defenses. The most common one is self-defense. An honest and reasonable belief that one is facing imminent harm. In contrast, an excuse affirmative defense is one that focuses on the actor itself, that somehow, for some reason, the defendant is not blameworthy. So in an excuse defense, the defendant affirms, yes, they committed the actus reus, and that the actus reus was in fact wrong, but due to special circumstances within the actor themselves, they are not blameworthy. And not guilty by reason of insanity is an excuse defense. You might also be familiar with a duress defense that gets raised from time to time as well. So, insanity is raised in 1% of all felony cases. So this is in contrast to the public perception. The public believes that insanity is a commonly raised defense, and that it's frequently successful, when in fact it's raised only 1% of the time in felony cases. And even when it's raised, it's usually unsuccessful. juries, especially due to their misperceptions about the insanity defense, are very unwilling to come back with a verdict of insanity. So if you're a defense attorney and you have an insanity case, I would advise you to seek a bench trial, because a judge is more likely to apply the law to the facts of the case and be open to an insanity defense than a juror might be. Now, for those people who are found to be insane, they're successful in their plea of insanity, that usually only occurs when all the medical opinions agree and the prosecution is willing to stipulate to a finding of insanity. So it's rare to have, although it does happen, but it's rare to have a defendant found to be insane and there's conflicting medical opinions. Now, when a defendant is found to be not guilty by reason of insanity, then they're referred for a second mental health evaluation to determine, are they committable? And I can tell you in Ohio that almost everyone who's found to be legally insane is also found to be committable. Then their case is retained by the trial court. So in contrast to someone facing ordinary civil commitment that's heard in probate court, the insanity acquittee's case is retained in the trial court, usually the court of common pleas. And then the next issue is what do we do with them? What's the least restrictive treatment setting to both treat the defendant and protect the public? And the vast majority of insanity acquittees are hospitalized at the state mental hospital. And the purpose of that is both to treat their mental illness, because it makes sense that if someone is so mentally ill that their mental illness causes them to break the law, it makes sense that they're going to need treatment for their illness. But also, even for those people who have maximized treatment and are still symptomatic, they still stay in the hospital in order to protect the public from them. Once in the hospital, then they undergo frequent violence risk assessments to determine what's the most appropriate setting for them. There's different levels of privileges in the hospital, anywhere from level 1, where they're always in a locked-in unit, to level 5, where they can go off the hospital grounds by themselves with no staff escort. And the whole goal there is to both treat them in the least restrictive setting, but also to give great weight to public safety in order to minimize the risk of reoffense. And in Ohio, we're pretty successful at that. We've only got about a 3% rate of reoffense among insanity acquittees. And I don't think we could even say that all of those who reoffend because of mental illness. Some reoffend due to other factors. It's also important to realize that not guilty by reason of insanity is an acquittal, so there's no punishment. It's technically a non-conviction. All right, well, just moving forward now. So when we do a sanity evaluation, we focus on the defendant's mental state at the time of the offense in order to determine their criminal responsibility. So the present mental state is not really the issue. We focus on the present mental state whenever we're looking at competence to stand trial and other different types of competencies that might arise. So we're trying to reconstruct the defendant's mental state at the time of the offense. And we'll talk about how we do that coming up. Now, you will hear the media, even judges, confuse these two terms, competency and sanity, and they mean very different things. So competency, at least in the issue of competence to stand trial, gets to a defendant's present mental state to determine are they triable, where sanity is the mental state at the time of the offense to determine are they responsible for their actions. Now, there have been references going back a millennia to not holding certain people responsible for their actions, both the mentally ill and children. And how the law has treated those two groups, actually, there's some similarities. So here's a quote from the Talmud. It's an ill thing to knock against a deaf mute, an imbecile, or a minor. So the imbecile, I guess, is the colloquial term for the mentally ill person, the minor, the child. He that wounds them is culpable, but if they wound others, they are not culpable, indicating that they are thought to not be responsible for their actions. In Rome, a child or insane person was not accountable for murder because The one is excused by the innocence of their intentions, the other by the fact of their misfortune. The child is excused by the innocence of their intentions because they have the mind of a child. The mentally ill, because they have the misfortune of having a mental illness, is also not accountable. This was a quote from Aristotle: "The person is morally responsible if knowledge of the circumstances and in the absence of external compulsion, he chooses to commit a specific act." So referencing that mental illness can present an external compulsion and influence someone's actions. Now, going back to some of the English common law, we had some of the, in the early ages, there was only a private system of compensation, that if someone broke the law, they had to make B-O-T, basically compensating the victim. So if I kill someone's sheep, the only thing I have to do is to pay the sheep owner for their loss. And if I don't do that, then there's a threat of possible war upon the sheep owner's clan, upon my clan. But Henry Bragdon and others began to merge the secular law, which is this private system of compensation, with the church law. The church law was more focused on intent of the wrongdoer, sin, and punishment of the wrongdoer. So once you begin to look at the intent, then you begin to look at, well, for these mentally ill people, are they able to form the intent to commit these offenses? And how do we decide who's responsible and who's not? And then what do we do with those who are not responsible? So again, how the mentally ill were treated parallels how they thought about children. So there was a number of different systems or standards to determine who's responsible. If a child could count up to 12 pence, they were thought to be responsible, 12 pennies. But if not, they were not responsible. There was Spigurnal, who was a judge in the court of King Edward I. If any of you have seen the movie Braveheart, remember that movie back in the mid-1990s? King Edward I, also known as Longshanks. Well, one of his judges was Spigurnal, and he had a rule that basically if someone can tell right from wrong in the global sense, that was the relevant standard. So if a defendant couldn't tell right from wrong in general, then they were not responsible. But if they could tell right from wrong in general, then they were responsible. Blackstone had a rule of 7, which stated that if a child was 7 years or younger, they were never responsible. If they were 14 years, 2 times 7, old, then they were always responsible. And between 7 and 14, it was a case-by-case assessment. All right, now moving forward to the past few centuries in English common law, there's been various standards for insanity that we're going to run through here specifically. So we talked already about the right-wrong test from Spigurnal. 1724, we had the case of Rex v. Arnold that established the wild beast test for insanity. This was good law for 75 years in England. So Arnold shot and wounded Lord Onslow, and he was tried and pled insanity. And the court developed this wild beast test, sometimes called the total test of insanity, and it's also a cognitive test, because you'll see they reference the defendant's memory and understanding, which are forms of cognition. So the wild beast test states a man must be totally deprived of his memory and understanding, so as not to know what he was doing, no more than an infant, a brute, or a wild beast. So that's a very high standard to meet. For those of you that have seen The Shining, I think this is a good picture of Jack Nicholson. He looks like a wild beast as he's entering. I think isn't this where he says, "Honey, I'm home," or here's Johnny. Yeah, right. Next, we have the trial of Earl Ferrers, also known as Lawrence Shirley. So he was an English nobleman who killed someone on his estate. And this was in 1760. And he pled insanity, and this is the first appearance of several things. One is standard for insanity called the irresistible impulse test. Now, he was unsuccessful. He was actually he was hanged, found guilty and hanged. But this is also the first example of a psychiatrist giving expert testimony. Dr. John Monroe was the second in a line of 4 Dr. Monroes, so father, son, grandson, and great-grandson, who were all superintendents in succession of Bethlehem Hospital, a large mental asylum in England, which actually is still operational today. So you've heard the phrase Bedlam. You know, it's Bedlam around here, it's crazy around here, so that's the slang term for Bethlehem Hospital. That's where that term comes from. James Hadfield was a man who had a delusion. He believed that God was going to destroy the world. And so Hadfield wished to stop that from happening. And he believed the only way he could prevent God from destroying the world, which would be for Hadfield to be killed himself. He thought about suicide, but he believed suicide was sinful. So he had to find some way to get himself killed, kind of like a suicide by cop. So he did something that was likely to get him killed, which was he took a shot at King George III as he watched him play. And so he was charged with the attempted murder of King George III. He pled insanity, and he had a very competent defense attorney named Thomas Erskine, who knew that Hadfield didn't meet the wild beast test for insanity, didn't have this total deprivation of his memory and understanding, but instead Hadfield had a single delusion. Remember that God was going to destroy the world, and that if Hadfield could somehow be killed himself, that would stop God and would save the world. So his defense attorney, Erskine, asked the court to apply a new standard for insanity. That's called the offspring of a delusion test. If the criminal act is the offspring or the result of a delusion, then he can be found to be legally insane. So he finishes up his definition here that delusion, therefore, where there was no frenzy or raving madness, as we see in the wild beast test, that is the true character of insanity. He was successful, and Hadfield was acquitted. And there's King George III, who later himself developed his mental illness. He had a blood disorder called peripheria. And you might have seen the movie, well, it's been about 25 years, called The Madness of King George, in which his mental illness is portrayed. Another of these famous cases, Bellingham, he was paranoid, shot Prime Minister Spencer Perceval, and he was tried under the insanity standard of whether he was incapable of judging between right and wrong. So just a global right from wrong test. And here is Mr. Bellingham. Right, next we have the Edward Oxford trial in 1840. So Oxford tried to assassinate Queen Victoria. And for those of you that have seen the series, is it called Victoria and Albert, or just Victoria? Portrays Queen Victoria and her consort, Albert. They actually show some of these people trying to kill Queen Victoria. So he pled insanity for the attempted murder of Queen Victoria. And we have the reappearance of this defense that first appeared in 1760, 80 years earlier, of the irresistible impulse test. And he was successful. He was found to be insane. And they defined irresistible impulse as some controlling disease was the acting power within which he could not resist, then he is not responsible. So as you think about it, what types of mental illnesses might cause someone to have an irresistible impulse? I think about maybe command hallucinations or bipolar mania. And this is still relevant because about a third of the states in the US have some form of irresistible impulse standard for insanity presently. So here's a rough drawing you can see there in the bottom left of the defendant shooting at Queen Victoria as she rode by in her carriage. Now we have the most influential insanity case, the trial of McNaughton. This actually was also shown in that Victoria and Albert. So 1843, we have Mr. McNaughton. He was a Scottish wood turner, and he had a number of paranoid delusions. And he wanted to stalk and kill the Prime Minister, Robert Peel. Here's Sir Robert Peel. Now, Peel was noteworthy because he organized a police force in London. So that's why police officers now in England are called peelers, or they're called bobbies. So anyway, McNaughton, due to his paranoia, stalked and wanted to kill Prime Minister Peel. And he took a shot at who he thought was Prime Minister Peel, but instead shot the man next to him, the unfortunate Lord Drummond, and Drummond was killed. So McNaughton was charged with the murder of Lord Drummond. He pled insanity. He was personally examined by 4 psychiatrists who all testified at the jury trial that McNaughton was legally insane. 3 other psychiatrists were in the courtroom who observed McNaughton's demeanor during trial and never actually personally evaluated him, but they also testified, just based on their observations, they thought that McNaughton was legally insane. Judge Tyndall, who was the trial court judge, told the jury the whole of the evidence is on one side, that all the evidence points to McNaughton as being legally insane. And the jury did not even retire to the jury room for deliberations. Instead, they put their heads together in the jury box in the courtroom, and after 2 minutes they said, "We agree, McNaughton is insane." And so he was acquitted, and this led to public outrage, which still happens today when a high-profile case goes back with a finding of insanity. So this caused Judge Tyndall to convene an appellate panel of judges to consider the insanity defense in England based on the public unhappiness about the McNaughton acquittal. And they developed a new standard for insanity called the McNaughton standard. So McNaughton himself wasn't tried under the McNaughton standard. Rather, the McNaughton standard, or the McNaughton rule, is the product of the appellate review of the insanity standard in England. And you think, well, was this a new standard? Well, it really wasn't, except for one important aspect. So it was a combination of the wild beast test and Spigurnal's right from wrong test, except, I'll show you here, and you don't have to read all this here. Well, the McNaughton rule says that someone can be insane if they don't know the nature and quality of the act, or they did not know the difference between right and wrong. And here's what's new. As opposed to Spigurnal with the global right from wrong, in the McNaughton standard, we look at, did the defendant know the right versus wrong with respect to the specific offense with which he's charged? That makes a lot more sense, doesn't it? You can be insane if you don't know the wrongfulness of the act. And what does wrongfulness mean? Well, it can mean many different things, and this is still a relevant issue today. It can mean legal wrongfulness, that someone knows what you're doing is illegal against the Ohio Revised Code. Or it can also be broken down into moral wrongfulness. Did the defendant know or believe, because of their mental illness, that they were doing the morally right thing? And you can break down moral wrongfulness into subjective and objective moral wrongfulness. Subjective is where a defendant believes, he personally believes what he's doing is morally right, whereas objective is he would believe others, and society would believe he was doing the morally right thing. So this happens quite a bit. We have defendants who know that they're breaking the law, but they believe they have an overriding moral obligation to commit the offense because some greater moral good will come about. So for example, I did a bench trial a couple of years ago in which a 20-year-old man with schizophrenia and various delusions stabbed to death a 70-year-old man he had met while trying to join the Freemasons. He definitely knew it was against the law, but he had a number of delusions that caused him to believe that if he joined the Freemasons, and he be elevated to as a godhead, that was his word, as a godlike figure, and that if he killed this one Freemason, that he could attain an everlasting peace for all of mankind. So he knew that it was against the law, but he believed had an overriding moral justification for the offense. He, in fact, was found to be legally insane. Well, how do we think about insanity in America? Well, Isaac Ray was the founder of forensic psychiatry in America, and 5 years before the McNaughton case in England, he wrote an influential book here called The Treatise on Medical Jurisprudence of Insanity. In fact, the McNaughton court, the appellate review actually referenced reading this book as they thought about the McNaughton rule in England. So a couple of standards developed in this country, the New Hampshire Doctrine, the Durham test, and then the Model Penal Code test that we'll go through. So this is from a case called State v. Pike in 1869, in which the standard for insanity would be the person could be insane if the act is a result of a mental disease or defect. This is not too different than the offspring of a delusion test in the Hadfield case. Basically, if the offense is the result of a mental disease or defect. Fast forward 85 years to 1954, we have the Durham standard that came out of the U.S. Court of Appeals, D.C. Circuit. And we have Judge David Bazelon. Now, Judge Bazelon here was the Chief Justice in the D.C. Circuit Court of Appeals. And this is back in the 1940s and 50s, whenever psychiatry was really kind of focused on Freudian psychoanalysis and psychotherapy. This is before the biological era of psychiatry. So Judge Bazelon went through his own psychoanalysis. And because of that, he valued highly psychological concepts as it relates to legal issues. In fact, as the Chief Justice of the D.C. Circuit Court of Appeals, Judge Bazelon was able to hire, usually have 2 full-time law clerks. And in place of having 2 lawyers as his law clerks, he had 1 lawyer and 1 psychiatrist. He had a full-time psychiatrist advising him. Because of his interest in psychiatry and the law, he was willing to hear a number of these appellate mental health cases. So he was willing to hear the Durham case, which on the face of it is not really a noteworthy case at all. Instead, Judge Bazelon was looking for an opportunity to develop a new insanity standard in America. And so he used this case as an opportunity. I think Durham had like a minor offense. He was charged with housebreaking or something like that. But so Judge Bazelon developed this new test, which actually was pretty similar to the State v. Pike definition. Just the language is a bit more elaborate. So the accused is not criminally responsible if the unlawful act is the product of his mental disease or defect. So the product rule, also known as the Durham rule. So there was an 18-fold increase in the number of successful insanity acquittees under the Durham rule, because someone could be found insane if they were antisocial, just if they had a criminal personality, no other mental illness, they could be found insane. And that led to some problems. So then there was a number of Durham progeny trying to rein in, trying to close the doors a bit. The doors had been sprung open with the Durham rule. So under McDonald v. U.S., 8 years later, they defined what it meant to have a mental disease or defect. In Washington v. U.S., they said that the psychiatrist could not testify to the ultimate issue. They can only testify using the language of the Durham standard. One more here, U.S. v. Blocker in 1970, in which they said specifically that antisocial personality disorder does not constitute a mental disease or defect for the purposes of insanity. Then finally, 18 years later, they abandoned the Durham rule. It was just unworkable. Too many people were found to be insane. Next, we have the Model Penal Code test for insanity. And again, it just combines 2 of the previous standards into, again, with a little bit more elaborate language here. So a person is not responsible for their criminal conduct if, at the time of the conduct, as a result of mental disease or defect, he lacks substantial capacity to do one of two things. Either to appreciate the criminality of his conduct, that sounds like the legal wrongfulness from the McNaughton test, or to conform his conduct to the requirements of the law. That really is just a restatement of this irresistible impulse test from, as you saw, it came from, 1760, from the trial of Earl Ferrers. Then we also have, the second part of this is that they exclude antisocial personality disorder for being the threshold mental disease or defect required for insanity. How many of you were born in the spring of, or were alive in the spring of 1981? Just a few, right? Well, I recall this, the shooting of Ronald Reagan by John Hinckley and the subsequent insanity trial of Hinckley. So this was major news in 1982. It was a high-profile, contested insanity trial in which John Hinckley was found to be legally insane for the attempted murder of President Reagan. And just like with the acquittal of McNaughton, more than a century earlier, there was outrage in America with the acquittal of John Hinckley. So because of that, at least in the federal jurisdiction, they passed in 1984 the Federal Insanity Defense Reform Act, in which they tightened up the standards. So it's a strict McNaughton standard in the federal jurisdiction. In fact, it doesn't only require a mental disease or defect, they put in the word severe, a severe mental disease or defect, and, I don't have it on the slide here, they actually tightened the standards for the release of insanity acquittee. And so you might have heard Hinckley was hospitalized at St. Elizabeth Hospital in Washington, D.C. for until just about 2 years ago. He made his way through the different levels of privileges and eventually was released on something called a conditional release, and now is living in an apartment, but he has compulsory outpatient treatment and he has to take all of his medication and follow a number of rules, all with the intent that he doesn't reoffend. So here's a summary of the insanity standards here on the pendulum, or a continuum of strict to most liberal. So the wild beast, again, the total test of insanity. The Durham standard, which is the product test, be insane if the offense is the product of a mental illness. Then someplace in the middle we have the McNaughton irresistible impulse and the model penal code test. Now presently, several states have abolished the insanity standard. I have a friend right now doing an insanity case in Utah, and the test is, did the defendant form the mens rea? No mention about mental disease or wrongfulness. Even though they've abolished it, they still they have an informal insanity defense. So if someone is found, they still get hospitalized if they're found to be not responsible. So even though it's been abolished, technically it still exists. So of the states who have the insanity standard, and it's over 40, all have a McNaughton standard, a wrongfulness standard. But then about a third of the states have a second avenue towards insanity, the irresistible impulse standard. In Ohio, we have both. You could be insane either if you didn't know the wrongfulness or had an irresistible impulse. Until about 1990, when they changed the law, they threw out irresistible impulse. And here's just some of the states they have thrown out, at least technically, the insanity defense. In states, other states place the burden on the defendant, and yet different states have different procedures for how to think about an insanity case. I know in Wisconsin, for example, they have a guilt phase in which the prosecution must prove that the defendant committed the actus reus, and then if they're successful, then the defense, in part two, then then they have the burden to prove that they meet the insanity standard. In Ohio, we don't do that. It's just a defendant has to affirm, yes, that he did the actus reus. It's to stipulate to that. So here's the Ohio standard, and I've summarized it here for you. So 2945.39. First of all, it starts out with a presumption of sanity, that we're all sane. And so the defense must bear the burden of proof, of proving that the defendant meets the standard for insanity by a preponderance of the evidence. And the standard is a two-part standard. So number one, at the time of the act, so we're going back to recreate the defendant's mental state at the time of the act. Did he have a severe mental disease or defect that caused him to not know the wrongfulness of the act? So if you take nothing else home from this lecture, this is what you should take home. This is the Ohio insanity standard. So when we evaluate these cases, we look very closely at the facts of the case, trying to reconstruct the defendant's mental state to see, did he have the requisite severe mental disease or defect? And if so, did it cause him to not know the wrongfulness of the offense? So here we are trying to look at these facts very closely. We're turning back the clock, again, trying to reconstruct the defendant's mental state. Now, sometimes we don't get these cases as forensic psychiatrists to evaluate until weeks or months after the offense. So again, we're trying to recreate the mental state. I know in 1996, whenever I was only 5 years into practice, I got an insanity case for the defendant who had killed his 3 children 12 years earlier, in 1984. So trying to reconstruct his mental state during the offense, and we'll talk about how we do that. But first of all, the procedures. So the defense attorney pleads insanity. They can pursue simultaneously a not guilty and not guilty by reason of insanity. When they plead insanity, then the court will order an insanity evaluation at one of the local forensic mental health centers. So in Ohio, the 88 courts of common pleas are served by 10 different forensic mental health centers. So these are psychiatric clinics that are usually in the courthouse that do nothing but mental health evaluations on criminal defendants, most often incompetence to stand trial and not guilty by reason of insanity. So in this county, we're served by the Court Psychiatric Clinic, which is on the 6th floor of the Justice Center. Summit County has something called the Psychodiagnostic Clinic that serves 5 counties surrounding Summit County. So they will do, as the court's expert, a sanity evaluation. And the defense is free to arrange for multiple mental health evaluations on their own, in addition to the court's expert through the local forensic center. The prosecution can also ask that they have an expert of their own choosing do the evaluation. And so I think this is interesting here. So it's a possible basis for appeal that a defendant requested but was denied additional sanity evaluations and were later convicted. So the standard is, did they use sound discretion in determining how many sanity evaluations should be done? Obviously, in low-level cases, only one is done, but if it's a high-profile murder case, or if there's conflicting sanity opinions, then there might be multiple opinions expressed. And I'll skip over here. All right, so how do we do these evaluations? Well, we first of all have to know the exact legal standard for insanity. It varies from state to state, between the state and federal jurisdictions. And then we have to determine the facts of the case and then apply the facts to the standard and develop, hopefully, a thought-out opinion based on the evidence. So how do we determine the facts of the case or to recreate the mental state during the offense? Well, we want to first look at the defendant's past medical and psychiatric records. It would be highly unusual for someone to be so mentally ill as to be legally insane but never having been before in mental health treatment. So I want to know what those records are. Is there an established diagnosis of bipolar disorder or schizophrenia? Is there a history of malingering? Or a history only of, let's say, substance abuse? So I want to know what this defendant's past symptoms have been and past diagnoses. Secondly, I want to look at if they were taken to a mental health facility close in time to the offense. I want those records. Sometimes people are in outpatient treatment and then they offend. Let's say they saw their outpatient psychiatrist on Monday and then committed a serious offense on Wednesday. So I want to see what their mental state was on Monday whenever they saw their outpatient psychiatrist. Likewise, some defendants, whenever they're arrested, the police pick up symptoms of mental illness and they take them to the hospital, to the emergency department, or they're even psychiatrically hospitalized. So I want to know what those records say, both in terms of the defendant's symptoms and what they say about the offense. I had a case a while back in Medina County where a young man, a 20-year-old man, got into an argument with his father. This young man had both a psychotic illness, but he also had some substance use problems and also some behavioral problems. So after arguing with his father, he left out of the father's house and he made his way through some woods to a train track crossing where a train track crossed the road. And so cars had to slow down as they went over the train tracks. And so our defendant waited there and he took some of the large stones that form the base where the rails lay on. He began throwing these large stones at cars that slowed down to pass over the train tracks. And he unfortunately threw a rock through a windshield occupied by an elderly couple, and they were injured. And so he was, the police were called. He was detained by the police and taken to the Cleveland Clinic Emergency Department, and he was hospitalized for a week in the psychiatric inpatient service. So I certainly wanted those records whenever I was called to do the evaluation. And those records indicated that he was actually not psychotic, that he was high on drugs, and that he had a rational motive for the offense. He told the nursing staff he was hoping to throw the rock in order to slow the car down so that he could pull the people out of the car and basically steal the car and drive away. So that's a rational motive. And he was found guilty despite his insanity plea. And those records were critical evidence. Next, I want to look at what the defendant said and did during the offense. Because remember, the legal standard is his mental state at the time of the offense, at the second of the offense. And so I want to know, as documented by the police officers, by the victim, and by witnesses, what this defendant said or did, because that might give us some insight into their mental state. Likewise, if the defendant is questioned by officers and gives either a verbal statement that's on videotape or a written statement, I want to have that because that's very, very critical evidence. Then I do a personal interview with the defendant at the forensic center, but again, this might be weeks to months after the offense, and so time can corrupt his memory, or maybe he's read the insanity standard. So I'll put less weight on what the defendant tells me weeks to months later, but instead put a lot of weight on the contemporaneous evidence. All right, so here again is the Ohio test for insanity. And let's break this down a little bit more now. So we have this thing called severe mental disease or defect. Anybody here have a background in psychology or know what the DSM-5 is? Okay. So the DSM-5, for those of you who don't know, it's a book published by the American Psychiatric Association, and it has all the diagnostic criteria for the mental illnesses. So for schizophrenia, it lists the various symptoms you must have, or bipolar disorder, or alcohol use disorder, or pedophilia. The point I'm getting to is that DSM-5 contains mental disorders, and that's a term of art, a mental disorder. So when you look at this standard then, they don't use the term mental disorder. They intentionally use a different term. So the term severe mental disease or defect, that's a legal term of art that appellate courts have interpreted to mean that certain DSM-5 mental disorders would constitute a mental disease or defect for the purposes of insanity, and certain other DSM-5 mental disorders would not. So, generally, under a mental disease, so psychotic disorders like schizophrenia, or something called schizoaffective disorder, or delusional disorder, they would all constitute a mental disease. Also, mood disorders like bipolar disorder, major depression, that would meet it. Organic brain disorders like dementia, so Alzheimer's dementia, or delirium, yes. Courts are split on how you deal with post-traumatic stress disorder and also something called multiple personality disorder. There's some question, does multiple personality disorder even exist? On the mental defect, so having low IQ, formerly known as mental retardation, now known as intellectual disability, that would constitute the mental defect for insanity. But you'll note there on the bottom bullet point on the left, voluntary intoxication with alcohol or drugs does not constitute a mental disease for insanity. So if I go out and use some crack cocaine or some crystal meth and I get psychotic, I cannot plead and I cannot use that as a basis for insanity. Paraphilias. Pedophilia is one of the paraphilias, basically a deviant sexual interest. And so courts have ruled that pedophilia and other types of paraphilias cannot be the basis of an insanity defense. Also, personality disorders. We talked about the antisocial personality disorder, but that and other forms of personality disorders would not meet the criteria. Here's a couple slides of some other paraphilias or issues that would not, so I guess cross-dressing, bestiality, alcohol intoxication or alcohol use disorder would not constitute insanity defense. There was a case in California where a man said he was a compulsive gambler, and he pled insanity based on this compulsive gambling, but the court didn't buy it. Because he wasn't charged with gambling, he was charged with interstate transportation of stolen goods. So they said there was not a direct enough link. Now there are a couple of circumstances where intoxication can be the basis of an insanity defense, just not voluntary intoxication. So involuntary intoxication. So if you're out and someone puts a roofie into your drink, or what we used to call a Mickey Finn, so you partake of the substance without your knowledge, then that can be the basis. There's also pathological intoxication. Certain ethnic groups have a very low tolerance to alcohol. They don't have a certain enzyme to metabolize alcohol in a proper fashion. So they have one drink and they're highly intoxicated. So that can be the basis if they have no prior knowledge that they carry this trait. Alcohol withdrawal. So in people who have severe alcohol problems, they can become delirious and even psychotic because that wasn't their kind of intent when they drank the alcohol withdrawal delirium, or something called Korsakoff's psychosis, which is a psychotic disorder based on long-term alcohol use. The person is psychotic long after the intoxication wears off. These two can also be the basis of an insanity defense. Well, let's look at the second arm of the test then. Evaluating the knowledge of wrongfulness at the time of the act. So we want to again look at what the defendant said or did during the offense to try and understand what the motive was, if they knew the wrongfulness of the offense, or they thought they were doing the right thing. So again, what they said or did is described by witnesses, by the victim, what they told officers when the police arrived, or if they gave a statement. It's very important. Again, I would put some weight on what they tell me later, but just not as much weight as I would with the contemporaneous. Then we look at their behavior. Let's say a defendant tries to hide evidence. So he discards the knife in a trash compactor versus leaving the knife out in full view for everyone to see. They wipe off the blood from their hands. They change their clothes. They don't do those things. That's all indicators of knowledge of wrongfulness. If they flee from the scene, if they leave the scene right away, or flee from police, versus staying on the scene because they believe they haven't done anything wrong, that's an important piece of information to know. If they lie about the offense, would be an indicator of knowledge of wrongfulness. Lie about their name. If they deny committing the offense, versus if they say, hey, I'm John McNaughton, I just killed this guy. That's because they believe he had done something right. If they don't cooperate with the investigation, can be an indicator of knowledge of wrongfulness. Now, some defendants call the police or call 911 after the offense. And prosecutors will try and make hay with this by saying, that's, on the face of it, strong evidence that he knew he had done something wrong. I think you really have to analyze what's the reason for calling 911. I had a case, I think I have it in the case examples here, where a man, he killed his wife with a ball-peen hammer while watching The Price is Right. Hit her by the table, she ran for the door, and finished her off by the door. He was in the midst of a psychotic depression. And then once he saw all the kind of blood and horror, he was kind of shocked back to his senses, and he called 911, but not to report a crime, but instead to call for help for his wife. So you have to take that into account. One thing in that fourth bullet point that we look at, if the person's psychotic belief were true, would the offense have been right? Because you can be mentally ill and still sane, right? Your mental illness has to cause you to not know the wrongfulness in order to be insane. So let's say that I have a belief that the gentleman here in the front, yes, you sir. Let's say I have a belief he's transmitting to me fatal brain waves. And I say, stop those brain waves, you're killing me. I believe that if I don't stop these brain waves in the next 30 seconds, my head's going to explode and I'll die. So I go and I push him down, and I'm charged with assault. Well, in that vignette, right, if he was actually doing something to me that was going to cause my death, I'd be justified under the doctrine of self-defense to assault him in order to protect my life. So in that example, if the delusion were true, then I'd be acting in a right fashion. In contrast, if I have a different delusion that he's had an extramarital affair with my wife, and I'm angry about that, still a delusion, right? But it wouldn't be justified under self-defense to push him. So if I push him because I'm angry about the perceived but psychotic affair, I can't be insane for that. Because again, if a delusion were true, I wouldn't be justified to commit the assault. We then look at the motive. Why do people break the law? Mentally ill people break the law for the same rational reasons that non-mentally ill people do. Anger, frustration, financial reasons, sexual gratification. They think they won't get caught. And so we look at, is there a rational motive versus is there a psychotic motive that caused them to believe that the offense was right? So again, this overriding moral justification based on a psychotic motive. Now, I get calls sometimes from prosecutors who say they'd like me to do an evaluation, and they say, listen, this defendant planned out this offense. Now he's pleading insanity. So isn't it just on the face of it that he planned it out, proof that he can't qualify for insanity? And I would debate that because there's a lot of mentally ill people who commit offenses after, a lot of prior planning. Again, the real test is, did they have the mental illness that caused them to not know the wrongfulness? We also have this thing called temporary insanity that people talk about, and I just want to tell you that it's not a true concept. There's nothing called temporary insanity in the law. Either someone qualifies for insanity or they don't. There's no temporary insanity. Do we take a break at the hour? Okay, so it's 2 o'clock now, so let's come back about 10 past then. All right, well, we're going to start again. So, if you're in a jurisdiction where there is an irresistible impulse on, and again, we did this in Ohio until 1990, there's some things that we look at. I had as I mentioned, I did this evaluation in 1996 of a man who in 1984 killed his 3 children, ages 2, 4, and 8. And he pled insanity, and so we got to assess him under this irresistible impulse. So these are some things that you look at. So especially, are they unable to refrain from the offense due to mental illness versus some other factors such as anger or intoxication? Are there consequences for failing to act? Have they tried any lesser alternatives? And have they had command hallucinations? I might as well tell you a story about the case because it's quite interesting. 22-year-old man with a psychotic illness and also a marijuana user. He had had 1 previous psychiatric hospitalization for psychosis, was discharged, was living with his girlfriend, And I think the 2-year-old was his, and the older children were his girlfriends. And one night he had a delusion, it was off his medication, a delusion that Satan had taken over his girlfriend and 3 children. And that if he didn't liberate Satan from his girlfriend and 3 children by sunrise, that Satan would take his girlfriend and 3 children to hell forever. So he thought, well, I got to do something here to get Satan out of my family. So the first part of the evening, he focused on his girlfriend. He tied her to the bed. He mixed his urine with some soil from a potted plant and made a poultice that he smeared on her, trying to get Satan out of her. It didn't work. He called his girlfriend's mother several times and said, can you help me? Can you come over here and help me get Satan out of her? And she didn't know what to do. He called the police and he said, can you come over here and help me get Satan out of my girlfriend? And they said, don't call back. So left with those unsuccessful attempts to accomplish his goal, he worked in this throughout the night, and then as sunrise began to come around, the 8-year-old got up and began to get ready for school and said, hey, we need some breakfast, it's time to go to school. So he then began to focus on the children. In fact, he killed the 3 children in the effort to get Satan out of their body. The girlfriend broke loose and called police. So 3 counts of capital murder, and he pled insanity. So as you think about that, under this irresistible impulse test, he wasn't drunk, he wasn't high, so his inability to resist or refrain was due to his psychotic beliefs. There were consequences for failing to commit the murders, that his girlfriend and the 3 children would go to hell forever with Satan. He tried lesser alternatives. Remember, he did the poultice, the rain dance, called the mother-in-law, called the police, and all those were unsuccessful. So now as the sun rose, he was faced with his only other avenue, and he killed the 3 kids. So he was found to be insane, and he was committed and is actually still in the hospital. So 33 years later, it's 1984, so 35 years later, he's still hospitalized and unfortunately still symptomatic. All right, so changing topics. So if you are at trial and you have one of these insanity cases, here are some things you might want to do on direct, is to establish the qualifications of your expert. That they're a psychiatrist or a psychologist, they're licensed, they're board certified, and that they've had special training in doing these sanity evaluations, because the general psychiatrist or psychologist won't. So you need someone who's had training specifically in forensic psychiatry or psychology. And then describe the sources of information, including their interview, the police records, the defendant's medical and mental health records. Then have them summarize the relevant details from all the contemporaneous evidence. Have them then express an opinion on the defendant's diagnosis at the time of the offense, and then walk through the 2 parts of the insanity standard. Did the defendant have the requisite severe mental disease or defect at the time of the offense? And if so, did it cause him to not know the wrongfulness? In contrast, if you're cross-examining an expert on the issue of sanity, regardless of whether their opinion was that the person was sane or insane, you want to ask, did they look at all the appropriate materials? Did they watch the videotape of the police interrogation? Did they talk with the victim or read the victim's statement? Have they received specialized training in doing these evaluations? Do they know what the legal standard is? You'd be surprised how many experts, not just on sanity, but in any kind of legal issue, form an opinion and testify not even knowing what the legal standard is. They make up their own standards. So if that's true, you want to point that out. Now, all these cases, the evidence is never 100% on one side. There's always conflicting evidence. And the expert does some weighing of the evidence. 4 facts point this way, 2 facts point this way. So you want to make hay, obviously, with the facts that weigh in the position that you were advocating for. Did the defendant have more than one diagnosis at the time of the offense? I think one of our examples I'll show you here shortly has that. And if so, do both diagnoses constitute the requisite severe mental disease or defect, or if one does not, was that the causal issue that led to the offense? Also, with respect to knowledge of wrongfulness, there's usually always conflicting evidence on that as well, so to point that out. This is just a little sidebar here. So this is an appellate case. So as I mentioned before, most insanity cases are heard at a bench trial. So the Ohio Court of Appeals has said that in a bench trial, the insanity verdict will be reversed only where there's overwhelming and uncontradicted evidence to the contrary that the court arbitrarily ignored. So it's a very high standard to have one of these verdicts overturned on appeal. So let's get now to our case that I showed you the 2 slides earlier of Philip, the man who killed his mother. So and as I show you more slides, I want you to think. Did he have symptoms of the severe mental disease or defect at the time of the offense? And if so, did it cause him to not know the wrongfulness of his actions? Look at how he describes what he did, what he said, what he thought, and form an opinion on this. Now, I will give you a disclaimer. So this account, this interview was given years after the offense. And so he's had successful treatment. He's had some time to kind of psychologically process the death of his mother. So don't hold it against him if he looks, number one, rational, but also less than emotional when he talks about this.
And it wasn't just my mother and my family, but it encompassed a lot, almost everything that I came in contact with. People. I mean, I was afraid of almost everybody. I mean, it was to the point where I would actually have butterflies in my stomach if people would say something to me. I was so fearful, you know. And it was hard, you know. I had a really hard time concentrating, and I became very impulsive. Certain words started to take on special meanings, like the word rat and chicken and light and darkness. Those words I thought were contained in a coded message that the evil people spoke, and it was used to keep me from understanding what they were really saying and what their real purpose was, which I thought was to, like I said, impede my progress on this mission. And I concentrated constantly on trying to figure out and break this code, so I figured that would help me understand my purpose too. Well, like I said, song lyrics, you know, were you know, I thought the songs were being sung directly to me, you know, and I can't recall right offhand, but different lyrics, I thought they were talking about me and or to me, or the Gulf War was going on at that time too, and there was a lot of news in the newspapers and on the television about the war, and I thought that war was being fought over me. And that had me very nervous too, because I didn't know what was going to happen. I started to get the feeling that the whole country, the United States, was an evil empire, and that they were persecuting the rest of the world. But most of the American people that were good didn't know about it, because they were fed propaganda constantly by the news media, and they were never exposed to that outside element to realize that these people were really good.
Okay. So he's doing a good job of describing his kind of multiple bizarre delusions.
People, and I was becoming more aware of things that I was never aware of before I had this spiritual enlightenment that I thought. And I said to my mom, I said, "Mom, I'm in hell, something's wrong with me." And she said, "No, honey, you're just not eating right. I'll fix you something to eat." So she went to the kitchen and she put something on the stove. I don't remember what it was now, but I got up out of the chair in the living room and I walked through the dining room to the entrance of the kitchen, and I just looked at her and I said, "You're the mother of Satan," and I punched her, and I hit her in the head, and she flew backwards and flew up against the kitchen cabinets, and she got up and she came forward to hug me, and I hit her again, and she went back this time onto her knees, and she was on her knees, like kneeling and looking at me, and she said to me, she said, "Your brother and Sandy, who was my wife, are outside the house. They want to talk to you." And now I look back on it now, I can kind of realize that she knew that there was something wrong with me, and she was just trying to get me to go outside, you know, so she could be okay. Well, I didn't think about it, and I kicked her in the head, and she collapsed on the floor in front of me, face down on the floor in the kitchen. And I don't know what made me do it, but it was like I didn't think about doing it, but I did it anyways. It was like there was no conscious level of thought when I did this, but I reached into a drawer in the kitchen cabinet, and my hand just grabbed a pair of scissors. It grabbed onto a pair of scissors, and I pulled the scissors out and I stabbed her one time in the back, which hit her lung. And of course my mother, she eventually died. She bled to death. And after I stabbed her, I turned off all the lights in the house because I thought it was an evil house. And I carried the scissors with me outside down the street, and I left and started to walk back to my house, which was approximately quarter to a half mile away from her house. And I remember I got to the top of her street, and I had those scissors in my hand, and I said, well, my mom's garbage, you know, so I should put these in the garbage can. So I set the scissors, I didn't hide them inside the garbage can, I just set them on top of the garbage can. And I finished walking back to my house, and I got to my house, and I called my wife, and I told her that I killed the mother of Satan. And she was pretty astonished. You know, she was in Orwell visiting her sister. And she said, what did you say you did? And I told her again. And she said, just stay there, and I'll call your brother. So she called my brother, and she told him what I did. And he called the police, first of all. Then he called me. And he said to me, he said, when I was talking to him on the phone, he asked me what I did. And I told him, and he said he was going to tie my fucking ass to a tree and set me on fire. Well, I guess that was just because he was mad, but to me, in the whole context of this satanic stuff and evilness and fire, I just assumed that I was right about everything I thought, and he was like the devil. And so I read the Bible, and it occurred to me that he might appear in my front yard some kind of way, like supernaturally, and there was going to be an ultimate battle between me and my brother, between good and evil, was going to occur. So I took a knife out of the drawer, and I had it with me, and I had a Bible in my front yard, and the police came. My brother, of course, never showed up because he lived in Lakewood, which was a little distance away. But the police arrested me, and they took me to Euclid City Jail, where the detectives interviewed me about what happened and everything. And I made a confession the best I could at that time to tell them, you know, what I was thinking, everything. People. Oh, I mean, I definitely thought I was killing the mother of Satan. That's how it seemed to me. But I didn't. My mother didn't look like Satan. There wasn't a visual hallucination there. It was just my thought telling me that this person was evil, and she was trying to impede me from this mission that I was on.
Just a few
going to free me, for one thing, because she was my mother. Yeah, I thought my family was evil, and that was going to free me from the bondage of evilness. Well, to me at the time, I was having all these thoughts. I thought that if I killed her, the world was going to come to an end, and that the angels would come, and there would be a battle like the Battle of Armageddon in the world, and it was going to be good against evil, and I would be the initiating cause of this whole scenario taking place if I accomplished it. Well,
if you hadn't have killed the mother of Satan, then what did you think was going to happen?
That things were just going to go on as the status quo, and the evil people were going to keep exploiting and using the good people, and the world nobody would ever see God or nothing. It would just keep going as it's been going.
Okay. Now, when the offense occurred then, did you know that there was laws against killing people?
That never really entered my mind. I didn't think about anything about laws or anything like that.
But you knew, though, that, you're 30 years old, 31 years old, you knew that on some level that it was against the law to kill other people.
Oh, definitely. I mean, if I was rational and I was on normal or on medication where I wasn't psychotic, I know murder's illegal, but things like that don't occur to you when you're in a state like that. That just doesn't happen,
If you had...
All right, so I think it's well established he had the first arm of the test, right? This is cerebral disease. He was psychotic. He had all these delusions about good and evil and his mother and being satanic and all that. So I think we can all agree he met the first arm of the test. But the real issue is, did his mental disease cause him to not know the wrongfulness of killing his mother? So who has an opinion on that? He said he knew that it was illegal, but he didn't really think about it. So in your mind, though, did his motive for the offense, did it override his knowledge of what he was doing was illegal?
I think he thinks it does.
So you think he's insane then? Now keep in mind, in Ohio, the term wrongfulness doesn't specify legal versus moral. It's up to the finder of fact to decide what type of wrongfulness to apply. Anybody else that saw another hand was up?
Yeah, it was me.
Uh-huh.
I don't know if I can insert this kind of opinion into it, but if he thought that he was killing the mother of Satan, then laws applied to humans wouldn't apply to that kind of figure. And so maybe even then, even if it would have crossed his mind, it wouldn't have affected his choices.
That's a good point. If you recall the original McNaughton language, it would involve not knowing the nature and quality of the act. And so you'd say, well, if he thought he wasn't killing a human being, but thought he was killing a satanic being, then it could be insane because he wasn't killing a human. But so just to kind of pin this down here, so what factors would support that he did not know the wrongfulness of his actions? I can think of a whole host of them. Way in the back there.
When he was talking to his brother, he specifically said that his brother was talking about lighting him on fire and validated his feelings that he was doing the right thing.
I think there's that part. I think there's also the fact that after the offense, just, in line with what you said, was he called his sister and told her what happened. And then when the brother called him back, he affirmed, yes, he had done this. So he didn't lie about killing the mother, which would be an indication that he had done something right, not wrong. What else? Huh?
He didn't hide the weapons, he just placed it because he associated his mother with garbage.
Well, that's an interesting piece of information there. So and I think that can go either way. He took the weapon from the scene. That might point towards knowledge of wrongfulness. And he said he put it on top of the trash can. So I think that can weigh either way. If you look at it as a fact in isolation, I think that can go either way. Huh?
He didn't try to evade the police at all. Like he was in his yard with a Bible and a knife, and they showed up, and he didn't say anything about conflict or resistance.
Right, he waited around for the police. Supposedly he cooperated with the police, didn't deny it, didn't say it's the wrong guy or what are you talking about. But though, remember after he killed her, he turned off the lights in the house. That, you could argue that would be one effort to avoid detection. And again, in isolation, you might make hay with that, but I think combined with all the other facts, that wouldn't be convincing. But he did turn off the lights, he left the house and took the weapon with him. So this is an example of, the information doesn't all point towards one way, it's usually conflicting. In the end though, he was found to be insane, but the idea was that he had this overriding moral justification, that it was right to kill his mother, who he believed was the mother of Satan, in order to bring about Armageddon that would then result in everlasting peace for all of mankind. And if he didn't do that, the world would continue to exist in this evil state. So that's a psychotic motive that caused him to believe he was doing the right thing. It was also not a rational motive. There's no evidence that he and Mom were arguing about something or had a dispute about money or, whatever else people argue about. So given the fact that he had this overriding moral justification based on psychotic motive, his behavior and statements at the time of the offense, and the lack of a rational motive, I think you can make a good case that he was legally insane, which the court agreed with. And this actually was taken from the hospital when he was hospitalized. And so again, this was taken years later, so he was hospitalized for many years. Any final comments on this guy before we leave this, or questions? Okay, now take a look at the standard, because I'm going to take it down and I'm going to put a couple of vignettes up, and I want us to kind of work through those as well. So again, at the time of the offense, presence of a subliminal disease or defect that causes the defendant to not know the wrongfulness of his actions. So why don't you read through this example, and we'll all form an opinion whether the defendant qualifies for insanity. So, did he meet the first arm? Did he have this subliminal disease or defect? Who says yes? Well, good, you've been paying attention. So, yeah, obviously flows from his voluntary use of PCP. And even though he was psychotic and, made a good case for psychotic self-defense, but given that it flowed from his voluntary use of PCP, he cannot be legally insane. These are all real cases. So why don't you read through number 2? So on the first arm, did Mr. B have the requisite severe mental disease or defect? Who says yes? Who says no? Good, right. So we have a history of schizophrenia, and then we have active psychotic beliefs or delusions about the hotel manager being a terrorist and working for Saddam Hussein, etc. Except that this is a real case, this was from 1995 or 6, so I guess it shows the relevant, who was, Saddam Hussein's long been dead. Anyway, so on the second arm of the test now, did his schizophrenia cause him to not know the wrongfulness? Who says yes? And who says no? I see we have some fence sitters. So you, sir, I saw that you raised your hand and said no. You in the kind of purple shirt there. What's your rationale for that?
Setting a fire is wrong in and of itself. In fact, he did it to bring police and fireworkers to the hotel. So that he knows it's wrong because that's what happens to people.
That's a good point. The police don't come when you do the right thing, right? He intentionally did something to bring the police. But I think the question is, was there an overriding moral justification? When you think about it, what kind of mental disorders really cause someone to not know the wrongfulness or to not know the legal wrongfulness? I mean, I can only think of a couple of things: dementia or intellectual disability that would cause someone to not know that the Ohio Revised Code prohibits certain behavior. The only other avenue would be in a paranoid self-defense, an example I gave earlier about the brainwaves. So the other avenue towards insanity is a case like this, where the person knows what you're doing is illegal, but they believe they have an overriding moral justification. So in this case, he actually was found to be insane because he believed it was right to start a fire in a motel room, a small fire, in order to prevent the greater harm of the terrorist explosion and plot. So he was found to be insane. Let's go on to the third example here. Another fire starter. All right, I will stipulate to the subliminal disease because he had schizophrenia, he was off his medications, and he did have some delusions. The one about the aliens monitoring the earth, and at least he said that he feared other group home residents would harm him. So that can be some paranoia. So I think we can all agree he met the first arm, but the real issue is did his mental disease cause him to not know the wrongfulness? So who has an opinion on that?
I would say that he did know the wrongfulness because he said he thought he received a ticket from the police and he's also doing it to be evicted and transferred to a new home.
I think those are both good points. So you don't get a ticket for doing the right thing. He just misestimated or underestimated the sanction he would receive. Said he was charged with arson. Also, he had a rational motive. So just because he's psychotic, there's no causal link between his psychotic delusions and starting of the fire. There was no psychotic motive which caused him to believe that the offense was right. Instead, he had a rational motive. He was angry with his friends for not sharing their beer and marijuana, and also because he thought that they would all lose the TV privileges. And he also thought that if he started a fire, he'd be transferred to another group home and get an upgrade in his conditions. So all rational motives. This is an example of how someone can be ill, yet offend due to a rational reason and not be insane. Any further comments or thoughts about this example? Okay, I've got two more for you. This was the guy with the ball peen hammer in The Price is Right. So just as in the other examples, I'll give you the first arm. So he had a history of major depression that would constitute mental disease. In fact, it was not only depression, but psychotic depression. And 3 years earlier, when hospitalized, he had the same delusion he had at the time of the offense, that his wife was ill and couldn't take care of himself. Plus he's suicidal, so these are all sufficient symptoms to meet the major depression with psychosis and meet the first arm of the standard. So the real issue here is that it caused him to not know the wrongfulness of his actions. So if you believe he was insane, raise your hand. And what's your rationale for thinking he was insane?
The delusion that he had mostly.
Sorry, the delusion that, okay, so he thought his wife was ill, couldn't take care of herself, okay? What else is there that would support that he did not know the wrongfulness?
So I think he does know the wrongfulness, but him believing that she was ill, unable to take care of herself, on top of his depression, his decision to commit suicide, I think that his moral justification was that if he was going to commit suicide, she would not be able to take care of herself. So I think, and this is more like a mercy killing, she might as well go out with him because she will be able to take care of herself anyways.
Right, that she was, that even though she didn't know it, she'd be better off dead. That was his psychotic thinking. How about the evidence to the contrary? How about the fact that he didn't tell his wife about it in advance? Do you have a comment?
Well, he was going to tell his wife because he thought she was ill. That sounds almost like some rational people would tell someone if they thought they were going to take care of themselves.
Right, and it's not legal. We don't have legal euthanasia, do we? How about that he hid the hammer? Didn't hid the hammer from the wife. So it's a very close call. This guy actually was found to be insane in a bench trial. I think if he had a jury trial, he would have been convicted. But found insane, went to the state hospital, and after a couple of years, he himself died of due to lung cancer. So. This is our final example then. All right, so he had this schizoaffective disorder, combination of schizophrenia with some mood symptoms. He had delusions, right? This delusion about the young adult women and the brain waves. And then we also have, on the day of the offense, he was non-compliant with his medications. So that's pretty compelling evidence for schizophrenic or schizoaffective disorder at the time of the offense. But does he have a second diagnosis? I see you nodding your head. What do you think he has?
Pedophilic impulses.
Yeah, he's a pedophile, right. So he has well, it says right here, history of pedophilic impulses and fantasies, and past history of pedophilic behavior. So, two different diagnoses. One would constitute the mental disease, one wouldn't qualify. So, the real question is then, did his severe mental disease of schizoaffective disorder cause him to not know the wrongfulness? Or was it something different? So who thinks he was insane? Good. Who thinks he was not insane? And how about way in the back row? Someone tell us why. What's your rationale is?
Well, you want the bowling alley, so you know. So you want that the car mother, so you knew he did it wrong.
Right. So that's one factor. You left the scene. In fact, he left the scene for the specific reason that he feared the police would be called. And you don't get the police called on you if you've done something right. Go ahead.
He didn't have the brainwave thing at that time, so that's not the schizophrenia, that's the pedophilia.
Right, there was no causal link between his delusions about brainwaves towards adult women. That was totally independent of his pedophilic urge towards this young girl. What else? How about his behavior? So he bribed her, right? Gave her $5. I think actually in the real vignette, he told her to not tell anybody as well. So that's knowledge of wrongfulness. So left the bowling alley, feared police. How about this final sentence though? He says he didn't believe he had committed a wrongful act. Well, isn't that slam dunk? He was insane?
His actions will show otherwise, so you can say that, but I think, like, his actions would show, his conduct would show that he did commit something wrong.
That's true, but there's also one other important factor.
He gives a justification, which is that his justification was the 6-year-old was attracted to him and he reciprocated that affection by paying her $5 to fund her. That's not an insanity, like that's a different rationale.
Right, that's a typical pedophilic justification for their behavior that's non-psychotic, and it's just that excuse. So, yeah, he was not insane, he was convicted. And all right, so, sir?
So what happens if there is a cross relationship between the antipsychotic and mood stabilizing meds and suppression of pedophilic motives? That is, if there's a relationship, you stop taking his antipsychotic and mood stabilizing meds, which then frees him to act on the pedophilic impulses. Does that happen? And where would that go on the standard?
Yeah, if we were in a jurisdiction that had this irresistible impulse, you can make that argument, but it can't be, it has to actually impair his knowledge of wrongfulness, cause him to think he's doing the right thing. So, other comments or questions? Yes?
What impact would it have if somebody was non-compliant with medications?
Right. That comes up sometimes. Is a defendant responsible if they're non-compliant with their medications and they become psychotic and offend? And the law does not hold them responsible. The reason is that, especially for these psychotic illnesses, lack of insight is a major symptom. And so people stop taking medications all the time because they think they're not ill. Their symptoms seem real, or they're on medication, they get better and think they don't need the medication, and their symptoms return slowly and subtly, so they don't realize they're getting sick again. So basically, a defendant is not held responsible if they voluntarily stop taking the medications. Any other final comments or questions? Yeah.
Of the 1% of defendants who raise the insanity defense, how many are women?
I think women are overrepresented in there's been some studies done, one done in Akron actually, that at least in those who are successful in being found insane, women are overrepresented. Anything else?
So I know this is probably a small amount of cases, but is there ever anything with like cults and like brainwashing? So I was watching a video of something like Charles Manson. Like, would that ever qualify as an insanity defense?
Yeah, we just gave a panel presentation at a national meeting last week in Baltimore on kind of atypical insanity defenses. Not really. There's the issue of duress. For those of you that were around back in the 70s, you might recall the Patty Hearst trial. Remember the Patty Hearst trial? So that can get raised whenever there's a kind of a cult-like thing. In Akron, I was involved in a duress murder trial with the Akron Summit County Craigslist killings in 2012, where a 16-year-old boy, his defense was he was coerced to participate in 4 murders by an older man who was a family friend. There's also this concept of Stockholm syndrome, that crime victims, especially those that are kept captive for a period of time, will identify with their captors and become sympathetic to them. But that goes down the avenue of duress, which is a very hard test to meet.
So just kind of going back to getting the judges, finding it more likely the juries that you are insane, is that because the juries have like an inherent, like you want to find someone, you want to find someone so to act, is that because why juries are more likely to not allow someone to get away with it for insanity?
Yeah, I think a couple reasons. One is, as I mentioned before, there's a lot of misperception about the insanity defense and what will happen to someone if they're found insane and about the impact of mental illness. There's also the concept of jury nullification. The jurors, once they get back in the jury room, they're going to do what they want to do. They're going to throw out the facts and the standard and just give it their gut feeling. And if they're not really tuned into mental health issues, you know, it just lowers the chance they'll come back with a verdict of insanity. All right, well, thanks for your attention and have a great weekend.